Hi, this is Jeff Cameron with Keller Williams. Thanks for tuning in to my series on before the foreclosure or short sale. What are my options? Today we're talking about option 2, which is, are you protected? So there are, well, before we even go into that, make sure, before you make up your decision here, you talk to professionals both in the legal aspect, an attorney regarding foreclosure, short sale, bankruptcy, one that's been involved in this process, and then on the other side, a CPA, one that also has been involved with this and knows the difference between what are we talking? The Mortgage Debt Forgiveness Act of 2007, how it works for investors, just the tax laws involved here, because you need to know that before you make the decision. So I kind of jumped into everything right there. Going down that one avenue, let's go back up to the banks, and when you're looking at whether or not a bank can come after you after you've done a foreclosure or after you've done a short sale, really you're looking at whether or not they have recourse or non-recourse. And some of the other factors involved there is whether or not it's a trustee sale as far as the foreclosure goes, or a judicial foreclosure, and then we have short sale. The other factor, or another alternative coming up, in April of 2010, we have the HAFA plan, which is the Home Affordable Foreclosure Alternative. And in the HAFA plan, if your lender is a part of this through the Making Home Affordable program with the government, if you go through a short sale with them, regardless of whether it's a recourse loan or not, part of that arrangement with the government and the banks is that they won't come back to you afterwards. So if you're in the HAFA program, now again, talk to an attorney before making a decision, but that's what one of the alternatives, or one of the possibilities there. Back to the IRS, I think I kind of talked about that. Our factors are whether it's owner-occupied, an investment property, whether or not it's purchase money, whether or not you've done a cash-out refinance, whether or not you qualify for the Mortgage Debt Forgiveness Act of 2007. So next I'm going to have a quick interview with Mark Windsor. He's an attorney with Windsor Coleman. They focus on short sales, foreclosure, advising clients. I hope you enjoy that. I hope you get a lot of value out of it. Give Mark or another attorney a call and answer your questions before you make your decision.
You have to understand that first.
Right.
And so we always analyze and we ask this question, or these questions. Is the property on 2.5 acres or less?
Okay.
Is it a single or dual dwelling? And if the answer is yes to both of those questions, then we know the property is of the kind, the type, that could be protected. And then there's 2 different laws. And that's what people forget as well. We don't have one anti-deficiency statute.
We got 2.
We have 2.
Cool.
So then we ask ourselves the final question. And either one of these will protect. If the lender chooses to foreclose with a trustee sale, then the lender cannot pursue the homeowner for that balance that we call a deficiency, assuming again that the property is on 2.5 acres or less and it's a single or dual dwelling.
Okay. So with foreclosure, we have a lot more protection for the homeowner.
If it's a trustee sale,
With a trustee sale, okay.
because the lender could choose to foreclose with a lawsuit, and that's a different kind of foreclosure. And this first law does not protect in a lawsuit foreclosure that we call a judicial foreclosure. It only protects in the trustee sale, which is the one they tape. They tape the notice on the door and say, "We're taking your home in 91 days."
Right.
That's the one that first law protects.
What's the other law?
The other one sounds similar, so it confuses people.
Okay.
It still says anti-deficiency, meaning it's still designed to protect from the lender coming against the homeowner for that difference between the value of the home and that loan. And it also requires the property to be 2.5 acres or less, and to be a single or dual dwelling.
Okay.
So a duplex or a single. So it's very similar that way. But the third requirement has nothing to do with the trustee sale or foreclosure, and that's where there's some disputes. But there's a case out there, and the way the statute is worded, I'm confident I'm right, but there's attorneys who disagree with me. But this statute, in my opinion, says if the money that was borrowed was used to buy that property, all or part of the money, I mean not all of it, just if any of that money was used to buy that property, then the homeowner is protected under that purchase money anti-deficiency statute. And in my opinion, it's regardless whether it's by foreclosure whether it's judicial or non-judicial, meaning whether it's foreclosure with a lawsuit, or whether it's foreclosure with a trustee sale, or whether it's a short sale.
Okay.
But there's attorneys who disagree with me, and I know Bank of America right now has one. It's not a suit yet, but a demand, and I know the homeowner's paying it. Although I wouldn't if I was the homeowner, I'd fight it. But they got deep pockets. Who's going to fight these lenders?
Wow. So this is a lot to take in, and I really think that the reality is just about every one of you, if you're watching this and you're in this position, you need to either start off with a phone call with somebody at Mark's office and just get some basic questions answered, or meet with Mark or one of his attorneys and find out if you're protected and whether or not you then can make your decision which direction you want to go at that point.